Senator Corbett?
I have a question. Could the person from the civil engineers please come back for just a moment? And anybody else who might want to answer the question, that's fine. I struggled with this bill last year as well, and I'm still struggling with this bill. I'm not an engineer. I've sat on the Business and Professions Committee in both houses, so I've had my share of engineering training by way of the B&P committees. And I'm having a hard time understanding, you know, obviously in some cases, and I'm not saying this as a practitioner, obviously there are people who are trained in engineering in the various different fields that are obviously highly competent, able to, you know, make decisions, sign off on projects, you know, have that experience and expertise. But I'm having a hard time understanding if that is true across the board in each individual engineering, you know, specialty. And I'm also having a hard time understanding this comment that civil engineers perhaps maybe aren't needed to sign off because these people have their experience and their expertise and it's just an added cost. Obviously, at some point when the law was created to allow that civil engineers are involved in this process in a sign-off or whatever way we want to characterize it, it was done for a good reason. And I'm having a hard time really understanding whether it is time to abandon the way things have been done, because the expertise and the training and the education of these specialties has evolved over time, and maybe it is needed now or it isn't needed anymore. For me, there's just so many moving parts. I'm having a hard time really determining what is the best thing to do. And I guess my broader question would be, why isn't the board addressing, I mean, maybe they have tried over the years, and obviously they probably have, but why isn't the board more involved in this issue that you actually raised, that there are individual specialties that, you know, have been certified appropriately or not certified appropriately? Why isn't the board more involved in sort of meting that all out?
Well, I can't speak to why the board's not involved today. I think that probably part of it is, and it was covered in your analysis, is that there's been a 20-year history of struggling over this, and the board has been more involved in the past, and ultimately we're still in this committee debating the same issue that we have been for almost 20 years. Getting to your other question, though, about the regulation of the practice in California, there are two distinct recognitions for regulating engineering practice in California, and one is the Practice Acts, which are the three recognized civil, electrical, and mechanical, and then there are the 9 Title Acts. The Practice Act engineers are regulated both for their use of their title, but also the practice of engineering. And so the statute and the regulations that the board have adopted cover both the use of their name as a civil or electrical mechanical engineer, but also define what those practice activities may include. Over the years, because of their own organizational desire, many of the Title Act engineers who are supporting this measure today sought to have a legislative endorsement of, I'm an engineer and I deserve to have some regulation. But unfortunately, where we stand today is those engineers' practice has never been regulated. Only the use of the title has been regulated. And so while there are the 9 Title Act engineers and 2, to make things even more confusing, 2 title authorities, the 9 Title Act engineers don't have a regulated practice. They are regulated over their use of the title, fire protection, traffic, etc. Many of them are jointly licensed. Many of them have a civil and or mechanical or electrical Practice Act engineer license in addition to the Title Act. But the board is constrained, and the only disciplinary action that may be taken against a Title Act engineer, if there is malpractice, is to remove their authority to use the title. There's nothing to stop someone from engaging in what is commonly referred to as agricultural or any of the 9 Title Acts design activities. Simply, they are proscribed from using that name as a Title Act engineer in any kind of commerce. It's a very confusing thing, and I think that many of the practitioners and the opponents to the bill would not have embraced this licensure method for the state of California. And I think the real conundrum is, how do we move from this rather confusing Practice Title Act situation to a more logical licensure scheme?
Don Reisner, representing the California Legislative Council of Professional Engineers. In 2005, the board sponsored legislation that's basically what we have in 692. They did so after a $450,000 study that demonstrated there's no reason that all engineering disciplines should not be treated the same, at the same level of respect, which is the law in every other state. Mr. Markison was involved in that study and is aware that all this took place. And as far as discipline of Title Act engineers, any licensed engineer pursuant to Rule 415 by the board is required to be competent whenever they provide any service. And that provision is codified in 692 to make sure there's no misunderstanding. If you're not competent and you do something as a licensed engineer, then you've got a problem. So as far as the respect that should be given to the various disciplines, Dean Lavernia should be able to answer those questions.
Larry Emerson.
Yeah, Dean Lavernia,
I'm sorry, did you want to respond?
We'll answer all questions.
The question I had is, there's been some discussion about that deans and the Title Act engineers are not fully tested for whatever they do their engineering on. Is that a true statement, or?
Well, so the professional engineering degree is a very basic entry-level requirement. Once you pass that exam, the definition of competence means that you deliver an engineering design that's within your expertise, and that will function as such. Failure to do so means that you're probably going to end up losing your job.
Yep, but they are tested on their expertise, on their training and expertise.
Yes.
And do you envision that they in any way would act or could act as a civil engineer?
No, they would only be able to act under their own competence.
Their own competence. Okay, thank you.
Any other discussion? Well, I know this has been a discussion we've been having for the past 20 years, as I understand, and I'm not convinced that we've got it clarified now. I'm not going to be able to support it as it's presented if it is not successful, though I think we can come back for reconsideration. What's the...
Yes,
okay.
Urgency clause.
All right. Is there a motion? Madam Secretary, please call the roll.
Price, Emerson,
Aye.
Emerson, I, Corbett, Correa, Hernandez, Negrete McLeod, Vargas, Walters, Wyland. One aye.
Okay, it's one aye.
I think she may have voted for her own.
Two
I'm
ayes.
sorry, I
Two
didn't hear
ayes.
you. I
decided
didn't
to
hear you.
support
Two
her
ayes.
bill.
Two ayes have it.
I didn't hear her.
That's encouraging.
She was vacillating.
That's
there.
progress.
I'd like to ask for reconsideration, and I know it's an urgency bill, so we would have to do a special hearing.
Yes, we'll arrange that.
Thank you.
Thank you. Okay.